Now we will look into the aspects of next branch of the government, that is the legislature. As the name itself indicates, legislature, legis has been derived from the Latin expression lex, that is the law. Legislation means the process of making the law. Law, as we have seen, is the command of the sovereign. It is the rules and regulations as made by a sovereign authority, accepted by the people at large. So, the purpose of legislature in a democracy is to make the law, laws for regulating and governing the entire country. So, the legislature is vested with the task of making the laws from time to time. So, now we will examine how the union legislature in India has been organized and laid down. India follows something called as bicameral system. So, at the time of making of the constitution makers specifically wanted to have the Westminster model of governance, that is the parliamentary form of governance as existed in the England or UK. So, here we have followed the same system and we have something called as bicameral system, that is a political system where you have two houses within the parliament. Two houses, bicameral means two houses within the parliament. Some of the parliaments are unicameral, that is they have only a single house. However, since we have followed the or adopted the British Westminster model, we have two. One is the House of House of People, also known as Lok Sabha, and the next one is Council of States, also known as the Rajya Sabha. So, two houses of parliament. However, the parliament, according to the constitution, not only includes Lok Sabha or Rajya Sabha, but it also includes the President of India, who is an essential part of the Union Parliament. Remember that President of India is also the constitutional head of the state and head of the Union Executive. Nevertheless, the law making process, which involves the participation of Lok Sabha and Rajya Sabha, essentially has a special role for the President of India to play. That is, until and unless a bill is being signed by the President of India, it doesn't become a law. So, to ensure that a bill becomes a law, the President of India should be there within the Parliament. So, even if he doesn't sit in the houses of the Parliament, nevertheless, he is part and parcel of the Union Parliament, which consists of both Lok Sabha and Rajya Sabha. Now, we will see the composition and parts of the Parliament, that is both the houses of the Parliament. Lok Sabha. Now, we will see the composition and membership of Lok Sabha. Lok Sabha, as the name indicates, it was earlier known as House of People. So, House of People means the members will be directly elected by the citizens of India through a system of secret ballot and a system of adult franchise. That is, any Indian citizen who has completed 18 years of age is eligible to vote in the general elections conducted every 5 years or earlier if the house has been dissolved. So, the maximum strength has been fixed at 552 members. Now, there is a proposal that this strength will be increased. However, first a study has to be conducted by the Delimitation Commission, which will propose the number of seats whether to increase or decrease. But as on date, the total strength of Lok Sabha is 552 members. And the elected members, the Lok Sabha has elected membership. That is, in order to become a member of Lok Sabha, a person has to be elected directly by the people. So, you have the entire country divided into territorial constituencies. You have the legal framework as laid down under the Representation of Peoples Act, which lays down who can participate in the election or who can stand as a nominee for the elections. Then you have direct election being done in the process called as first past the post system. First past the post system, that is a simple version whereby the candidate securing highest number of votes is declared as the winner from that particular respective constituencies. So, here we have the first past post system used in the direct election, and the people, the MPs are elected from the territorial constituencies. Some of the constituencies where they have the predominant population of scheduled castes and scheduled tribes are reserved for them. But nevertheless, when it comes to the electors, you don't have any kind of reservation. Electors can elect irrespective of their caste differences or their economic status. Then representation will be there from states and union territories. The seats in Lok Sabha is decided in accordance with the population which, or in proportion to the population of that concerned state or union territories. So, based upon the population of a concerned state, the seats in the Lok Sabha are decided. That is the reason that the states having high population tend to have high number of seats in the Lok Sabha. And the term of Lok Sabha is 5 years. So, a person getting elected to the Lok Sabha, that is MP, usually enjoy or general elections are held for a period of after 5 years. That is, the term for each MP is usually 5 years. However, it can be curtailed if it has been dissolved earlier. If the Lok Sabha has been dissolved by the President of India, then in that particular situation, there can be a term lesser than 5 years. However, the term of Lok Sabha can be increased 1 year at a time during the proclamation of national emergency. So, if for instance, the national emergency has been imposed and the term of Lok Sabha is about to expire during that imposition of emergency, then it can be extended at a time for a period of 1 year for n number of times. So, after 1 year again they have to place a resolution and extend the term for a period of 1 year more. So, it cannot be extended indefinitely. So, it can be extended maximum up to 1 year during the existence of national emergency, only during that particular period of time. Now, coming to the upper house, also known as the Council of States, that is Rajya Sabha. Rajya Sabha earlier during the British era was also known as the Chamber of Princes. Now that we have abolished the princely states in India, we have only the system of the states being represented directly in the Rajya Sabha. So, it is also known as the Council of Elders or Upper House. So, here we will see that the maximum strength is fixed at 250 members. The maximum strength of Rajya Sabha is 250 members, and out of those 250, 238 are elected by the MLAs of different states, and 12 are nominated by the President of India. 12 experts from various fields are nominated by the President of India, like arts, literature, social service, etc. So, the prominent persons, the 12 prominent persons will be nominated to the Rajya Sabha. And remember, unlike Lok Sabha, Rajya Sabha is a permanent house. That is, it cannot be dissolved, whereby you will find that each MP of Rajya Sabha will have a term of 6 years and 1/3 of the members retire for every 2 years. So, after 6 years term, a panel will be prepared where 1/3 of the strength of the Rajya Sabha retires. So, the term for Member of Parliament of Rajya Sabha, MP Rajya Sabha, is 6 years, whereas the term of Member of Lok Sabha is only 5 years. And Lok Sabha can be dissolved, but Rajya Sabha cannot be dissolved. It is a permanent house. Now, we will see what are the powers and functions of the Union Parliament. First and foremost task, that is obviously it is the legislative power, that is power to make laws on the subjects in the concurrent list. Power to make laws on the subjects which are mentioned in the Union and concurrent list, Union and concurrent list. So, Schedule 7 of the Constitution speaks about the division of legislative powers, that is law making powers between the center and states. So, it contains the list of subject matters on which Parliament can make the law, the state government can make the law, and both Parliament and state government can make the law. So, with respect to the subjects which are reserved for the union government, that is union list, obviously the Parliament is authorized to make the law, and with respect to the subjects which are reserved for both Parliament and state government, in that particular list also the Parliament can always make the law. Then when it comes to the executive powers, it controls the government. it controls the government. Just now we have seen that in the Council of Ministers, always should have the confidence of the Lok Sabha. They are collectively responsible to the Lok Sabha, and if they are not responsible, then they can be brought down through passing of no confidence motion. So therefore you can say that the Parliament in fact controls the executive authority, that is the government. The government is actually controlled by the Parliament. And then you have certain financial powers conferred upon the Parliament, that is passing the budget and approving the taxes. Budget, which is also known as annual financial statement, is placed before the houses of the Parliament, and it is the Parliament which is authorized to approve new taxes which can be applied to the people in India. So without the approval of the Parliament, no taxes can be imposed on any person. No taxes can be imposed, not even a single rupee can be imposed on any person until and unless you have a parliamentary approval. So when it comes to the financial powers, it passes the budget, and until and unless the Parliament of India passes the budget will not be actually implemented. And the government officers cannot withdraw any kind of money from the treasury until and unless they have the express authorization given by the Parliament. So therefore, the Parliament significantly controls the government's treasury. Coming to the judicial parts of the Parliament, we will see that even though the task of making of laws is being vested with the Parliament, it also has certain powers which are judicial in nature, that is, which resemble the judiciary, that is courts of law. That is in the case of impeachment. In the case of impeachment of president or removal of judges. So judges of Supreme Court of India as well as the High Court of India are removed in a process similar to that of impeachment. So when it comes to the president, impeachment of president and removal of the judges of Supreme Court and High Court, the Parliament actually acts like a court, whereby it frames the charges as well as it investigates into its charges and renders its judgment in the form of a resolution. So even though it may be through resolution, but it acts like a court of law when it comes to the impeachment of the President of India and also the removal of judges. Then we have constitutional powers. So this power is exclusively, even though the powers of the Parliament, Union Parliament and the state legislatures resemble, but however, they are not identical. That is, power to amend the constitution is only vested with the Parliament. The power to amend the constitution or to bring out any kind of constitutional amendment is given exclusively to the Parliament of India. It is only the Parliament of India which can amend the constitution. State legislatures have no say when it comes to the amending of the constitution. The state legislatures cannot amend the constitution. It is only the Union Parliament which is vested with the powers of amending the constitution. Then comes electoral functions, that is electing the president and the vice president. As we have seen earlier, the electoral college for electing a person as the President of India consists of elected members of both Lok Sabha as well as Rajya Sabha and the state legislative assemblies. So the Parliament of India plays a crucial role. Why? Because the entire electoral college consists of the members of Lok Sabha and Rajya Sabha. And next one is in vice presidential elections. Here both the members of Lok Sabha and Rajya Sabha, they are going to vote. So therefore, they discharge the judicial powers whenever they are speaking about the impeachment of the president and removal of the judges. Constitutional powers, that is amending the constitution. Constitution can only be amended by the Union Parliament. However, remember, this power is not unlimited. This power is subject to judicial scrutiny, and the amending power of the Parliament should not extend to the extent of destroying the basic structure. That is, they cannot take away the essence of the constitution by way of constitutional amendment. So this is the constitutional power which has been laid down upon the Union legislature. Then we have electoral functions. electoral functions, they function as a body which elects the President of India as well as the Vice President of India. Then what is the law making procedure? As I told you earlier, it is being prescribed by the Constitution, and the Constitution itself confers the power to legislate, that is to make laws upon the Union Parliament. So what kind of laws are usually made? One is the ordinary bill. Ordinary bill, before it becomes the law, in initial stages it is known, the draft is known as bill. So it is introduced in the either houses. It can be introduced in Lok Sabha or it can be introduced in the Rajya Sabha, and it has to be passed by both the houses. As soon as it has been passed by both the houses, then it receives the President's approval. The President will say yes after it has been passed by both the houses. Usually he says yes, but however in certain cases the President has got veto power whereby he can withhold giving the assent, or he can simply remain silent by not giving the assent. So as long as he doesn't give the assent, it doesn't become a law. So therefore, in the case of ordinary bill, it can be introduced in either houses of the Parliament, and it should be passed by both houses of the Parliament. It can be through simple majority, or it can be through special majority, that is 2/3 of the members present and voting, or 2/3 with the 50% ratification of the states. That is the complicated procedure. Then you have, as soon as it has been passed by both the houses, if the President signs or gives assent, then it becomes a law. Then we have money bill. Now when it comes to the money bill, these kind of bills are exclusively dealing with some of the financial aspects of the country, crucial financial aspects of the country, that is withdrawing of the money from the consolidated fund of India, taxing the people. So that kind of provisions usually are treated as money bill, and money bills can only be introduced in Lok Sabha. So when it comes to the money bill, Lok Sabha has upper hand. Lok Sabha has upper hand when a bill is introduced as a money bill. And remember, money bills, a bill in order to become a money bill has to be certified by the Speaker of Lok Sabha. Only when he certifies a bill as a money bill, then only it can be treated as such. And Rajya Sabha, in case of money bill, can only suggest changes. It can only suggest changes. It can only say that you can have this kind of recommendations, etc. However, the suggestions as made by the Rajya Sabha are not binding on the Lok Sabha. Lok Sabha may reconsider those suggestions or may simply go with its previous choice. So as soon as the Lok Sabha doesn't listen to the Rajya Sabha also, it is fine. So President's approval is given to the money bill. So as soon as the President gives his assent to the money bill, it becomes the law. Now we are speaking about next category of bill, that is one of the crucial ones, that is Constitutional Amendment Bill. So Constitutional Amendment Bill can only be introduced with the prior consent of the President of India in the Lok Sabha. And as soon as Constitutional Amendment Bill is introduced, and if it passes the Lok Sabha through special majority, that is 2/3 majority, then it will go to the Rajya Sabha, and Rajya Sabha can only suggest changes. Rajya Sabha can only suggest changes. The Rajya Sabha cannot say no to the constitutional amendment as passed by the Lok Sabha. Then special majority, that is 2/3 majority of the members present and voting of each house is required for a constitutional amendment bill to become amending act. So here usually what happens is, as soon as Constitutional Amendment Bill has been passed by both the houses, there in that particular case, the President shall give his assent. The President shall give his assent. Why? Because it was only with the prior permission of the President of India that the Constitutional Amendment Bill can be placed before the Lok Sabha. Without the prior permission of the President of India, it is not possible to introduce Constitutional Amendment Bill in the Lok Sabha. Private members cannot introduce any kind of Constitutional Amendment Bill in the Lok Sabha. So that is the reason. If the President himself has permitted for the government to place constitutional amendment before the House, he cannot say no by withholding his assent. He cannot say no by withholding the assent. So, since he was the one who has initiated all these particular aspects of the constitutional amendment, then it is placed before him for his assent only for formal approval, only for formal approval. Nevertheless, his assent is mandatory to say that the amending bill has become amending act. So, it is essential. So, in the law making procedure, we have seen that the ordinary bill doesn't involve much task. Money bills requires special provisions, and when it comes to the constitutional amendment bills, they are the most important ones. So, these are the basic outlines for the law making procedure, but the actual law making procedure which is followed is far more complicated. So, to make a law itself is the task of the legislature. However, the legislature by brute majority cannot make any kind of laws which are that easy or which can be passed that easily. So, whatever decision they take, since it is going to have a wider implication on the public at large, then it is necessary that they have to be deliberated in the House. That is, proper discussions should be held, proper feedback has to be taken, proper amendments have to be moved, proper modifications have to be made before it is finally passed as the law. So, we have seen that these houses, both the houses of the Parliament, act as the houses for deliberation. So, even though the power is conferred upon them to make the law, that doesn't imply that they can make whatever law they want. It has to be duly passed by both the houses, and only when the President of India gives his assent to that particular passed bill, then only it becomes the law. So, this process is followed in the democratical system. More or less same sort of processes can be found in the other democracies around the world. So, this ensures that a particular piece of legislation is duly deliberated and it has been properly passed, duly passed in accordance with the procedures and law as laid down in the Constitution. So, therefore, we can say that the legislature is under heavy responsibility to ensure that they follow all the procedures and pass the law which is promoting the welfare of the citizens at large.